in progress. All right. Today, we're going to talk about breaches of contract. There's several types. All right, so implement a claims management program is the task, but what they're talking about is a breach. So, nature of a breach of contract. So that's defined as an unjustifiable failure to perform terms of a contract. And there's two types of contract breaches. There's material breaches, which involves key elements of the agreement not being provided or undertaken as stipulated. So a material breach is a bad thing. More complex contracts will specify what constitutes a material breach. I don't think we do in our LTAs. And the non-breaching party is relieved of their obligations under the contract by the other party's breach. So if there is a material breach of the contract, you don't have to perform your side of it. Damaged parties can then claim remedies. So you stop performing on the contract, which means you stop buying parts from them or paying them. And then you try to go back and take them to court and claim remedies. Remedies are designed to place the injured party in the position they would be in if not for the breach. So covering lost sales and that type of thing. So the material breach, and then there's the minor breach. Involves some minor element of the agreement not being provided as stipulated. So it does not lead to the cancellation of the contract, and the injuring party must remedy the situation. So a minor breach happens when you don't receive an item or service by the due date. So if they're shipping late, it's a minor breach of contract. So material or minor breaches also fall under one of two categories. So you can have material or minor anticipatory breaches or actual breaches. So an anticipatory breach is one party of the agreement stating that they will not fulfill their part of the obligations before they are due to do so. So they're just saying, we're not going to do anything more on this contract. The injured party can still claim remedies, and it's the future looking forward. That's the anticipatory breach. The actual breach is one party does not perform as part of the obligations as stipulated. It's past looking back. So under the anticipatory breach, they really haven't breached the contract yet, but they say they will. So you can take them to court over that. And the actual breach, they've actually breached the contract. Stakeholder engagement. Once a breach occurs, solicit the input from all the affected stakeholders. You need to understand full consequences of the breach, and the stakeholder can also recommend remedies, especially if you're working indirect type of stuff where you're working with particular internal customers. Establishment of harm. When a contract breach appears, supply management needs to document harm. So damages must be clearly ascertainable, and proof of harm, including its causes, needs to be established. So you have to start documenting. If you want to be compensated for lost business, you have to start documenting that somehow. Then you have termination options. So rights or obligations based on prior performance survive. So you'll see this is the last paragraph in our LTAs. It says these certain paragraphs will survive the contract, and it's stuff like warranty and intellectual property. So no matter how you terminate the contract, that stuff, warranty and intellectual property and some others will still survive and be in force. So if you terminate for cause, that's the cancellation of the contract. Implies cause and leaves causing party liable for damages due to a breach or default. So if they don't make the part, then it's a main material breach of contract, and you can cancel the contract for cause. For convenience, must be part of the agreement, can include payments for profits and work completed. You'll see this in our LTAs. Now, it doesn't get into, sometimes it gets thrown out in the negotiations, but it starts there, where we can terminate for any particular reason we want to. Frustration of purpose is another termination option. Under the Universal Commercial Code, a contract can be terminated if it becomes commercially impracticable for one party to perform. Wars, natural disasters, pandemics. This is along the lines of acts of God. So as the same applies, you can't say you're not making money, so you got a frustration of purpose. Or material prices increase, which is based not making money. You can also terminate for inexcusable delay. A delay cannot be justified as a true force majeure event, but must be a contract clause permitting it. So just because your profits went up or dropped and the material prices went up, that's not force majeure or frustration of purpose or inexcusable delay. But if they don't ship because they say that profits have dropped, then it can be frustration of purpose or inexcusable delay. Contractual remedies, so compensatory damages. There's two types of compensatory damages. There's general damages and special or consequential damages. So under general damages, it's awarded to the plaintiff, who is the damaged party. The defendant would be the other party, the breaching party. So the damages restore the buyer to the position he or she would have been in had the contract been fulfilled. So if you lost sales due to the contract breach or et cetera, and you got all that documented, that monetary damage will restore you to the position you would have been in. And then there's special or consequential damages. These are damages awarded for issues like loss of business or loss of profits. So the general damages are more concrete. I'm trying to think of what would be a good example, but the special or consequential damages are what suppliers really don't like to put in a long-term agreement, because it's things like loss of business or loss of profits. And it's basically a very open-ended liability. So that's why suppliers really don't like it. Specific performance is a non-monetary award where the defendant must perform some aspect of the contract. So instead of being awarded money for damages, the judge may just make a specific performance and say they have to do such and such. And then there's punitive damages. These are awarded for deliberate wrongdoing and service punishment. So also referred to as exemplary damages, and not typically allowed in contract disputes. So you have to show a deliberate wrongdoing and an intent to damage the other party to get these punitive damages. And this is usually more along a criminal aspect than a civil one that you'd see on normal contract disputes. Liquidated damages. So this is a sum agreed upon during the formation of the contract, which will be paid by the breaching party in the event of a defined breach of contract. For example, future lost profits. That could be a liquidated damage. And then here's a breach letter that the ISM guys recommend. And you just fill in the parts in red. Basically says this is notice being sent, pursuant to the agreement, you did this. However, despite the requirements of contract, you failed. And that's it. Here's my little guy. I like him. All right, claims assertion. The injured party must inform the breaching party in writing of the breach. So it's got to be done in writing. Written notice is provided of the breach to the breaching party. Must provide a dated letter indicating the injured party will be acting. You must give the breaching party an opportunity to cure the breach and avoid cancellation. Basically, cure the breach means fix whatever they screwed up. And a notice of default or breach letter may include things like reference to the statutory right, demand for payment, description of the damage, description of the incident, name, phone number, and all that good stuff. Then there's resolution. If no resolution can be found in a collaborative effort with the breaching party, then it's time to go nuclear and file a lawsuit. A lawsuit is a civil action. It's brought in a court of law in which the plaintiff, which is the injured party, a party who claims to have been incurred a loss as a result of the defendant's actions, demands a legal remedy, also known as suing someone or some entity. The conduct of a lawsuit is called litigation. So you don't, Packard rarely sues its suppliers, but every once in a while we do get caught up in lawsuits. Damages that the injured party, the plaintiff, may be entitled to include the following: actual damages, punitive damages, specific performance. We kind of discussed a lot of this already. And alternative dispute resolution, otherwise known as ADR, or external dispute resolution, EDR. So techniques that act as a means for disagreeing parties to come to agreement. Three different classifications for commercial transaction. You got negotiation, which is what we usually do here at Packard. You got mediation, which is an impartial third party assists disputing parties in resolving a conflict. It's non-binding though. So the mediator kind of works as a judge, but their rulings are non-binding, and they should be impartial, and they're a facilitator. And you've got conciliation. The parties to a dispute use a conciliator who meets with the parties both separately and together to resolve their differences. So conciliation differs from mediation in that conciliation, the parties need to restore or repair a relationship, either personal or business, rather than dissolve it. So there's been a breach, there's been a problem, and then you can do a conciliation to kind of get back on track with that supplier. Then the other thing is arbitration. This is be decided by one or more persons, the arbitrators, or arbitral tribunal, which renders the arbitration award. So it's a legally binding award. And it's often used for resolution of commercial disputes, particularly in the context of international commercial transactions. It's also frequently employed in consumer and employment matters in the US. So pretty sure I signed an arbitration agreement when I hired on at Packard. It may be mandated by the terms of the employment or the commercial contracts and include a waiver of the right to bring a class action claim. All right. If the plaintiff sends a notice of breach letter to the defendant, then what is the contract termination option that is in use?
For cause, option
Yeah,
A.
yeah. It could maybe be frustration of purpose, but I'm pretty sure it's going to be A. A is correct. What is wrong with C? Because you would use a frustration of purpose termination when it's no longer possible to be able to fulfill the contract. Oh, that's war. Okay. And one more. Which answer below best defines liquidated damages? I think the first two are kind of red herrings.
Yeah.
And the commercial code doesn't award damages automatically. So that would leave D. Let's see what these guys say. D it is. Liquidated damages refers to an amount agreed during contractual formation. So if you breach, we've already got in writing that you'll pay me X $1 million.
Yep, that makes sense.
Yeah. All right. There's 5 questions out there, so why don't you go ahead and get on them. Just raise your hand when you get done. All right, let's go over some answers here. One is option Charlie. Shipment of a product is a minor breach. Late shipment is a minor breach contract. 2 is Bravo. Acme has stopped shipping the product, which is a material breach. 3 is Charlie, because consequential or special damages covers items like loss of profits or revenue. 4 is also Charlie. A conciliation is a type of mediation, but centers on repairing the relationship. And 5 is also Charlie. Stopping shipment would be a material breach of the contract. In fact, the supplier is threatening and that future shipments will be affected. It makes it an anticipatory breach. All right. One more section tomorrow, and then we're off for a week.
Thank you, Rick.
All right. See you, Aaron. Bye.
See ya.